Hello, everyone. Welcome to the Hidden Histories Collective. I am Chris Robinson Jordan, genealogist and historian, and I know that it has been a significant minute, and I know I've not been sleeping, but I have been working on so many projects, but I have not forgotten about birthright citizenship at all. And in some ways, I'm kind of glad that I paused and delayed making a video on this when the oral arguments for this case occurred on April the 1st, because so much has happened since then. I mean, a lot has happened, as you guys are aware. And we are, in some ways, I don't want to say getting to the home stretch on this case, but it is definitely reaching a pivotal moment here, because the Supreme Court should be handing down a decision any day now. For the most part, they're trying to get through a lot of the cases before the summer session ends, and I anticipate that would be towards the end of June or early July. But they're also going to be making a decision on some cases actually Thursday, on June 11th. So I don't know if the birthright citizenship case is going to be included in that batch, but in any case, we are here, and it's going to be really interesting. And either way we go, this debate is not going to really end. But I think it's important that we revisit it and ask some really important questions. I have significant questions that I think many people don't ask enough of. But in any case, what I want to do is I want to go back and do a bit of a recap to the case, just so that we're all on the same page and that you guys can kind of see my reasoning a bit. Now, as you guys know, this Supreme Court case was sparked, I guess you could say, by President Trump's executive order 14160. And that was back in, I want to say, January of 2025. So time has been going by so quickly. So when the oral arguments occurred, they were, the government was represented by D. John Sauer. He's the Solicitor General of the United States. And then there was Cecilia Wong, who is the National Legal Director for the ACLU. And basically, the government was basically saying that the administration could, go through the effort of questioning the subject, the quote, subject to the jurisdiction thereof, and saying that does not automatically include all children born in the United States. And so the government maintains that the 14th Amendment should be basically interpreted in light of the historical meaning and limits. So, of course, the ACLU countered and argued on behalf of the plaintiffs, challenging the executive order 14160 and basically defending the traditional understanding of birthright citizenship as we know it. And they argue that the Constitution's text, federal statute, and Supreme Court precedent protect the citizenship for children born on U.S. soil. And I will be giving you guys the links to those oral arguments, many of which are very detailed and gives you an idea, a glimpse into not only what the government was thinking, what the ACLU was thinking, but also, most importantly, what the Supreme Court was thinking. And we'll get into that later. Now, again, like I mentioned earlier, the executive order was signed on January 20th, 2025, and that is what sparked everything set off. And the name of that order was Protecting the Meaning and Value of American Citizenship. Now, a lot of people will say, well, the president couldn't or should not have written that executive order. He can't change the Constitution. And that is true. Interestingly, though, and I mentioned this in previous videos, that even though the president cannot change or alter the meaning of the Constitution, the irony was that the only reason that we have this case in front of the Supreme Court is because the president actually wrote the executive order, which sparked the litigation in the first place. And if you guys look at previous videos I've made, I'll actually give you that link where I actually explain the why of the Trump administration's strategy. Because without him having written that executive order, the case probably would have never came to the Supreme Court at all. So, but once that executive order was written, then it triggered the administration to say, okay, federal agencies, now we are basically directing you to deny citizenship recognition to certain children born in the United States. And those children specifically are children of parents who are not documented or who are or were in the country temporarily. Now, what was interesting about all of this was that on June 27th, that is when the plaintiffs filed their lawsuit. Okay, that is what triggered everything. And then after that, then they basically filed the lawsuit in the U.S. District Court for New Hampshire, which is where I guess you could say I won't say it's an easy district, but in terms of I guess you could say the more left-leaning ideas. I'm trying to be as politically correct as I can. It probably was the best district. And I also explained that in previous videos as well. So basically, the plaintiffs claimed that the executive order violated the citizenship clause of the 14th Amendment, and that they said that the birthright citizenship cannot be restricted by executive order. So now what we have here is a constitutional question, right? And the question is, can a president alter birthright citizenship without amending the Constitution? Well, we know that in order to amend the Constitution, Congress has to first write laws, then they have to debate them, and then states have to ratify or approve those amendments. So it's a whole process, which we can get into at a later date, but it definitely is a process. And that process can take literally months to years, as we know historically it has. Now, like with all things, right now the status is federal agencies continue to issue citizenship documents under existing law, such as passports, consular reports of birth abroad, and other citizenship documentation continue to be issued pursuant to current law and existing court orders. So as long as this case is pending or has been for a while, passports have been issued. Yeah. Now, the fundamental question that everyone's talking about, most people are talking about in legal circles, is when we interpret the Constitution, should courts focus on why a provision was written or on what the words actually say? And that is where we are right now with this particular case, because now we're going back to having to reinterpret the 14th Amendment and what the framers and writers or the authors of the Constitution meant by it all. But I want to give a bit of a timeline to all of this. Now, in 1866, the amendment was proposed by Congress on July 13th, 1866. And as many of you know, this followed the Civil War, which ended in 1865. Now, it took another 2 years for the amendment to be ratified, which was ratified on July 9th, 1868, after meeting the required 3/4 of states, right? So it still took a minute, and there were plenty of debates, not only in the media, but also amongst lawmakers. So, and with all that being said, there was a lot of debates about what was going to happen to the country amid Reconstruction. And there were tons of discussions around freedom, citizenship, and equality under the law. And it was affecting everyone. Everyone was a part of this, these debates. Now, again, we have to be ethical about this too, because I know a lot of people are saying, oh, well, it meant that everybody born in the U.S. should be a citizen. And I think that if we're going to have a really cogent discussion around it, we've got to really be ethical. And we have to talk about the original purpose of this citizenship clause. And it was adopted after the Civil War to ensure citizenship for formerly enslaved people and to overturn the effects of Dred Scott versus Sandford. Okay. And that is, to me, there's law and there's also ethics. And we have to be ethical in the understanding of how the 14th Amendment came to be, because you can't talk about the 14th Amendment, the 13th, 14th, 15th Amendment in a vacuum. They're all connected. The 13th Amendment being the abolition of slavery in the United States, the 14th Amendment and the 15th Amendment, which is, to grant voting rights to formerly enslaved people. And all of those were put together as what we now call them the Reconstruction Amendments. Now, of course, should interpretation remain tied to that historical purpose? And we're going to get into that in a minute here. Now, when we talk about all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Now, the wording was very broad. And of course, the counter argument to all of that is the Constitution does not say all formerly enslaved people are citizens. It says all persons born are naturalized in the United States, et cetera, et cetera. And that is typically when you go through the Constitution, they are very specific and they use all, everyone, persons, it is very broad in wording, right? Now, of course, the central debate, again, is if a constitutional provision was written to address a specific injustice, but expressed in universal language, should courts interpret it according to its original purpose or its broader wording today? And that is why we're here. That is why things are getting had gotten so confusing with this particular case. And for some people, it's very, very black and white. But I'm going to get into a central question I have in a minute. But, I just wanted to kind of drive this home a bit because I think it's important that we all kind of sit with that for a moment so that we don't lose sight as to what the 14th Amendment was in the beginning, historically. Because I know people can split hairs and say, oh, no, that doesn't matter anymore. Well, it does matter, and it did matter back then. And there was no confusion about that. So now I'm going to speak to the universal language for a minute because I think it's important that we be, honest about that as well. Now, while the political debate focused on, the formerly enslaved and freedmen, Congress was also aware of immigrant populations. Now, and a lot of that doesn't get talked about, but there were also a lot of immigrants in the United States, and many of them had not gone through a naturalization process, right? So what do you do with all the immigrants that are in the country that may not have been, quote unquote, citizens, if you will? So, but what, and I'm saying out loud without going into like a lot of long, laborious history, is that the language was chosen, yes, to include the formerly enslaved, but that also meant that it included, did not exclude the U.S. born children of immigrants. Yeah, we have to be really aware of that as well, that there were many immigrant children in the United States that were also going to be born here, and they were also going to become citizens based on the amendment. It's deep stuff, and there's a lot to that. So the broad language also keeps, it in some ways it puts at bay some of the headaches that will come in the future. But there's a lot to that. And again, it's very deep. I know that the framers weren't just thinking about the immigrant children, but they knew that they existed. But that wasn't the focus of the amendment. But I just had to say that because a lot of people historically are aware of this, but they also forget it as well. So now for Barbara versus Trump, this case is more than about citizenship. It really asks this larger question: how should constitutional meaning be determined? And the reason why this is a question is because let's face it, you've got 9 justices, and they don't all agree on the law. So sometimes you're going to have a 5-4 decision. Sometimes you're going to have a 6-2 decision. Sometimes you're going to have a 9-0 decision. So again, this whole idea of what the Constitution means is not just based on a justice's sensibilities, but also how they interpret the law. Right. And so that has to be said. We can't sit here and say, oh, well, the law is absolute and it's universal and it makes total sense. And yes, for some people it does. But we also are realizing that the law is also, yes, open to interpretation. And so what one person sees, another person may not see on the court. And that's really important that we make that distinction. Now, when we talk about Wong Kim Ark and the 1898 decision that defined birthright citizenship, and I won't go into a lot of detail about Wong Kim Ark. I'll be providing links to those videos where we talk about that at length. But the biggest reason why this case is important is because it may be a case that the Supreme Court continues to uphold. Right? Now, here's where things get interesting. Subject to the jurisdiction thereof. It's a small phrase, but it is garnered a big debate, and it has lasted for so many decades. And these 5 words in the 14th Amendment has shaped generations of legal decisions and the ongoing struggle for full equality in the United States. So it's deep, but I'm gonna try to add some clarity to it a bit. Now, when they did the oral arguments on April 1st, the government's view was that, when you talk about the subject, the phrase, it really is about full political allegiance. And the phrase subject to the jurisdiction thereof refers to people who are fully part of the political community in the United States. And those born to parents who are in the U.S. unlawfully are not subject to its jurisdiction in the constitutional sense and therefore are not citizens at birth. So now the ACLU says, but the phrase means subject to the laws of the United States. And anyone born on U.S. soil is under the protection and authority of U.S. law, regardless of their parents' immigration status. And that is all the amendment requires. Okay? Now, this is where it gets really interesting, because when you talk about the jurisdiction, it's like who belongs where. Yeah. And I think this is where it gets really dicey, but I'm going to try to add some clarity to it based on my research and what I've discovered, and really using some common sense when it comes to the law. Now, the question I have, and this is again just research, if jurisdiction means subject to U.S. law in the way that the ACLU positions it, why can the U.S. remove or deport that person? So the power to remove shows that the individual's presence and status are not beyond the control of U.S. law. So to me, that suggests jurisdiction is conditional or limited and not absolute. Okay. So if, in other words, a jurisdiction can be withdrawn, it's not the same as allegiance that is owed permanently. Right. So yes, you are subject to U.S. laws, meaning that you can be prosecuted, you can be detained like any other U.S. citizen. Like there's many things that you will be held accountable to. Right. At the same time, if you can be removed and deported, then that means I don't have, when I say I don't mean I, me personally, that suggests to me that there is conditional or limited jurisdiction. That would seem fair, right? Now, here's the other thing to drive the point home even further, is foreign sovereignty still exists because that person is still a citizen of another country. So therefore, the person is not exclusively under U.S. authority. So they're not fully subject to the jurisdiction of the U.S., which is what the government was arguing. Now, again, with all respect to the ACLU, yes, the subject is, if you're here undocumented or illegally, you are still subject to U.S. laws. But here's the thing about that. When all the deportations that have happened in the last few months, I mean, you're talking about a few thousand people, upwards of, they say 1 million people have been deported. Now, some of those people committed a lot of crimes, but they didn't prosecute them. They just put them on, a plane or a bus and tell them to go to another country, or basically ship them to another country. So, and here's the thing about that. Their country can assert rights over them, which means that their citizenship gives that country ongoing legal and political ties. And their country can even demand their return. And we've seen this happen too, where there have been highly publicized cases where we've had to swap citizens for, and deals and things of that nature, because that person is not fully under our jurisdiction, right? And of course, that has had to be, that occurs through diplomatic negotiations and discussions and things of that nature. But that country can demand that you return that person back, right? And they can seek repatriation. So again, that person is not exclusively under U.S. authority. They're not fully subject to the jurisdiction of the U.S., but we don't have to ever ship anybody back. We can keep them right here too, as well. So it all is about what the government decides that they want to do with that individual. So that whole concept of under the jurisdiction thereof, that is what I've not often heard in these major debates. Some people have said it, but driving it really, really home, saying, okay, but you're not under the jurisdiction if we can deport you, right? So anyway, that is what a lot of, that was the central question that I had around jurisdiction. Now, in the Wong Kim Ark case, Chief Justice Melville Fuller, he wrote the dissenting opinion. Now, he, along with Justice Harlan, were the dissenting voices on that case. So it was a 6-2 decision. Now, Fuller, his view was that citizenship requires complete political allegiance to the United States at birth and not merely birth within the U.S. territory. And here's what's really interesting. I'll also provide you guys the link to Fuller's decision or his opinion. And it's very, very insightful. And I highly encourage everyone to read it. One of the phrases and quotes he says is, "This cannot apply to our colored fellow citizens who never were aliens, were never beyond the jurisdiction of the United States." So in Fuller's dissenting opinion, he's basically saying he wasn't referring to immigrants. He wasn't referring to anybody other than, as he called them, quote unquote, colored fellow citizens. And we were never aliens. We were never foreigners. We were never from another place. Right? Now, of course, people could quibble and say, oh, well, we were from Africa, but okay, fine. But in his wording, he said that we weren't immigrants in the sense of what we know to be an immigrant back in those days and even now today. And we were never beyond the jurisdiction of the United States. So I find that really fascinating. So in his dissent, he was talking specifically about the formerly enslaved who were, quote unquote, colored. Of course, we don't use that term anymore. But I just wanted to share that dissenting opinion that Fuller wrote. And I'd be really, really interested to see the dissenting opinion, if there are any, on this case for the final decision here in the Supreme Court. Now, I'm going to do a brief oral argument analysis based on the transcripts of what I heard and everything that I heard during the oral arguments. And really the oral arguments were Sauer and ACLU basically arguing their case. But then, of course, what was really interesting was what the Supreme Court justices asked, what their comments were, and that really kind of gave you their initial feelings and thoughts about things. But that doesn't necessarily mean that they're not going to do the opposite. Because sometimes, you could try to read the tea leaves, but that never really works all the time. So, but basically what I heard, what the Supreme Court seemed to be signaling to me, and many people would probably agree to this, they were definitely skeptical of limiting birthright citizenship. And as I've said in previous videos, very rarely does the Supreme Court reverse previous decisions, but they've done it. They've done it on historical cases before, like the Board of Education, as you know, the abortion case. So there's been a lot of high-profile cases where they've reversed their decision. So I wouldn't get too comfortable. But in any case, the justices also emphasized that the plain text of the 14th Amendment was right there for everyone to see. They were quite clear, okay, this is what it meant. Now, they also had repeated concerns about who can be excluded and by what authority. In other words, can a president just go and write executive orders and change things and kind of enforce new law? And so we know that that's not our process. So, of course, they were going to push back on that. We know that to be true. Now, again, and I've mentioned this too, again, in previous videos about stare decisis, and the justices, from what I could hear, really was using Wong Kim Ark as a controlling precedent and affirming that birth on U.S. soil automatically equals citizenship. And they were showing some bit of reluctance to overturn a narrow, long-standing doctrine. Even the more conservative justices had questions about that. And again, they were really concerned about executive overreach, skeptical that a president can redefine citizenship via executive order, emphasis on the separation of powers, and suggested that changes must come from Congress or constitutional amendment. Now, granted, President Trump and his legal team are, I'm sure, quite aware that they cannot change law all the time through executive order. But what they did know was that if he had not written that executive order, there would not have been it would not have spurred any lawsuits. And that's just a legal strategy that President Trump has been using throughout his administration. And, without him doing that, we wouldn't even be here. We'd still be in the same space we were before. So that's the irony about executive order. Now, one of the things that I also heard from the justices was that they were focusing on the child's citizenship, not the parents. And, again, it always goes back to allegiance, but for the more liberal justices, they were not concerned about whether a child's parent was undocumented. They weren't really that concerned. They were just focusing strictly on the law. And there was no indication that the court will even try to redefine parental immigration status. Like, that's not why they were there. That's not what we're going to be talking about, at least not in this case. I mean, that's just not what their role is going to be. They're not immigration judges or anything like that. So, but here is the rub. If the court upholds birthright citizenship, yes, the child is a U.S. citizen, but guess what? It's still not going to change the parent status. It's not going to change the mixed status, issue that we have. And if you guys are paying attention to this, the Trump administration has been very, very intense on making sure that no one's crossing that border. No one's going to be coming into the country illegally. They have put so many restrictions on people who are even visiting by issuing bonds, and even for the H-1B1 visas that employers need to have, quote unquote, foreign workers. Those fees are going up. It's insane. It's intense, you guys. And I was going to show you all the immigration changes. I mean, there's probably about maybe 20 to 30 changes. I mean, changes that the administration has been pretty intense about. So there's that. And then just today, I think it was like $7 billion budget that they passed today. The Senate passed today to fund for 3 years the Department of Homeland Security to bump up and beef up the immigration enforcement. So yeah, I think that vote was like 216 to 214. Yeah, it's pretty deep. So in terms of immigration status, or immigration enforcement, the government's pretty intense on that. So yeah, again, regardless of the court's decision, the immigration enforcement will remain a central issue. And the mixed status households are still going to be an issue here. And there's, a few million people that are in the country who are undocumented, even with their children here. So, again, Congress is going to continue to fund the enforcement efforts. And the executive branch, particularly, is going to continue to implement immigration policy. They're really going to be implementing policy. And the Supreme Court's role is to determine the constitutional limits of those actions. So, they'll be there to say, okay, you can do this or you can't do that. So the legal dynamic around what the Trump administration is doing to enforce immigration law is pretty intense in a way that we haven't seen in a very, very long time. So we will see what happens, you guys. I think it's going to be pretty heady here, and it's not going to be an easy road no matter what the decision is. And I really believe that at some point, Congress is going to be forced to define what a citizen is, and, really define it, because we can't continue going down this road with this much uncertainty. So anyway, that is the presentation for now. I'm going to be watching closely when that decision is made, and we'll probably come back and revisit that and do another video on what comes next in the next few days. So you guys, thank you all so much for joining us on the Hidden Histories Collective. My name is LaCris Robinson Jordan, and please, if you haven't done so already, sign up for our newsletter on hiddenhistoriescollective.com, which will also be in the description of the video. And thank you all so much for joining us, and we will be talking to you all really soon. Have a great evening.